Hello and welcome to The Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for over a decade. We are recording this on Wednesday, July 22nd, 2026. In this week's episode, a Tennessee mother charged with murder after allegedly shooting a man she found hiding under her 13-year-old daughter's bed. Plus, the woman at the center of a salacious murder plot involving her husband and her 15-year-old lover seeks a new trial more than 30 years after her conviction. But first, the preliminary hearing for singer David, who has been charged with murdering an underage runaway that he allegedly had a sexual relationship with. Today, we are joined by Jason Goldman, a high-profile criminal defense attorney and legal analyst you can catch on multiple outlets. Jason, welcome, my friend. How are you?
Thank you for having me, Josh. I'm great. How are you?
I'm doing very well. And I'm glad that we have a criminal defense attorney on to talk to us today, because some of these issues are a little nuanced and they're very serious cases, especially the first one. So let's jump right in. Out of Los Angeles, California, my neck of the woods, singer David was back in court for a preliminary hearing as gruesome details in the slaying of Celeste Rivas Hernandez revealed to her family and a small pool of onlookers. David, whose legal name is David Burke, is charged with murder and the continuous sexual abuse of a child under the age of 14, along with unlawful mutilation of human remains in the death of Rivas. The victim's mutilated remains were discovered in a Tesla registered to Burke back in September of last year, one day after what would have been her 15th birthday. Prosecutors claim that Burke fatally stabbed Rivas the day after the couple had an argument, with Rivas allegedly threatening to oust the pair's illicit relationship, and Burke fearful of the implications on his burgeoning music career. Prosecutors began to lay out their case this week as a judge determines if there's enough probable cause to move forward to trial. Evidence included graphic photos of Rivas's body, which drew strong reactions from her family in the courtroom. Additional exhibits included allegations that Burke purchased items to dismember and dispose of her body online, including a shovel, chainsaws, and a body bag, along with an inflatable pool to contain her blood. While no cameras or recording devices are allowed inside the courtroom, 10 members of the public will be allowed to view the proceedings each day, determined via lottery at the courthouse. The preliminary hearing is expected to last through the week, and we will continue to keep you updated as this case moves forward. Jason, just about one of the most horrific and heartbreaking cases you can imagine. But explain to us a little bit exactly what a preliminary hearing is for our listeners so they understand. And then why would it be necessary, in your opinion, to include so much graphic evidence at this stage?
Yeah, well, I think first and foremost, just to educate the listeners, a preliminary hearing obviously takes place in California, some other states. Unfortunately, in my state of New York, we don't have one, but it's a way to just establish that there's enough to go forward. It's not about guilt or innocence or someone being guilty or not guilty. It's to show, quite frankly, the court that's presiding over the case that there's enough evidence to move forward to the next stages and ultimately head towards a trial. So it establishes evidence, it establishes a record, it establishes that, again, that there's enough to at least maintain the charges right now.
What do they do in New York? Is it all by indictment, grand jury?
It's all by indictment. There technically is a statute that does allow for a preliminary hearing. There was some interesting stuff happening during COVID with some issues with getting grand juries impaneled, but 99.999% of the time it's an indictment, and we don't have a preliminary hearing. So we don't have a shot at having live testimony. Obviously, there are suppression hearings at some point in time closer to trial where we can examine constitutional issues, but nothing like this, nothing like a preview of the evidence in the trial as a whole. It's really, my understanding, specific, of course, to California, and I believe some other states have it as well.
I'm curious about this, and I don't want to get too much into the weeds, but because it is different, I'm used to a prelim process. A lot of states have it. I just came from Utah, where they had the prelim of Tyler Robinson. So it's kind of pick your poison, I guess, depending on the state how they want to do it. But even on the low level, kind of straightforward felonies, do those all still go in front of a grand jury?
all in front of a grand jury,
Wow.
straightforward indictment. So, for better or for worse, and usually for worse, there's not too much of a record heading into it. Obviously, we're entitled to the grand jury minutes in New York State court. So we do get the transcript, and that, adds a layer of impeachment sometimes, but no cross-examination, no second bite at the apple, unfortunately, no deposition, no nothing until live trial, essentially.
One, referencing the Robinson case again, one of the big contentions that the defense had in that case is that during the prelim, they objected to a lot of the evidence as feeling like it would poison the jury pool.
Right.
And I'm curious, do you think that's a concern here in this case or in any case, really? I mean, they're putting on fairly graphic evidence. Is that something to be worried about?
I gave it some thought, and I certainly thought about it as it pertains to the case of David that we're speaking of right now. And initially, you would think that it's very prejudicial and very concerning for the defense. That being said, there's something that takes place when a government overtries or overpromises their case. And I was kind of re-examining a little bit of the P. Diddy case recently. And there was so much salacious evidence and things that got leaked out to the media and things pre-trial that I think the jury went in expecting a whole lot of stuff that ultimately did not come out. And the case was almost overtried before it even made its way to a jury. So in one regard, the gruesome pictures, which maybe could be limited later on in an actual trial, or I read something about, prosecutors putting in a brief that David had watched the victim bleed out on the street, things that might not make it into a trial. It's almost like overpromising in your opening statement. The jury might get there and say, I heard all these things, or I saw all these things in the papers. This case isn't about that. And it could be a backdoor way, quite frankly, for the defense to, be the ones that might be more credible heading into the case. I know that took place. Again, we're talking about federal court with the P. Diddy case, but that was really on display there where so much was leaked out and the jurors expected so much. And then it got to trial and it wasn't about that. It was about, things that were much different. The limine rulings went in favor of the defense, and it was a much more tailored down version of things. So that's one way to look at it from a defense attorney's lens. But obviously, we're all very cautious about poisoning a jury pool with, on the opposite side, things coming in that the jury should never see or hear, the potential jury should never see or hear. That's the reason why we have, rulings ahead of trial about what's going to come in or not. So.
Speaking of the defense in this case was very aggressive early on about saying they are not afraid. They want their trial. They, in fact, initially did not waive time on the prelim. For our listeners to understand, in California, if the defense doesn't waive time, they have to put on a prelim, no matter how complex the case, within 10 days of that person's arraignment. So that's lightning quick when it comes to the law. Something that the defense has an advantage in, that they kind of control the clock. Here, even though they did waive some time, we're still at prelim within weeks of him being arraigned on a potential death penalty case. One, do you think that is a little fast? And two, do you think this strategy of the defense and kind of saying, let's get this in front of a judge might have backfired on them a little bit?
I don't know if it backfired, because I don't know if things were going to necessarily get better for them if the case was extended out. I think in their mind, and I it's a bit of speculation, but I think that they thought that there were some issues with how the police investigated the case. There were some interesting delays between the discovery of the body and the autopsy report and the autopsy findings and the arrest. And I think that they thought that this might get butchered if it was handled quickly or in the wrong way or rushed to a certain extent, right? They took their time more so than usual. And, the conversation may have been, look, let's put our foot on the gas. Let's make them do this in 10 days or in a month or two, as opposed to really stretching it out, and see if we can catch them either lacking in further investigation. Because I've had cases before, certainly in federal court, where at the very beginning, the client is saying, I don't want to waive speedy trial. Let's not. And you know what? They were right, because sometimes when you waive it, what happens? There's additional phone search warrants. The investigation's always ongoing, right? And 2 years later, A lot of these cases do get strengthened. Sometimes justice delayed is justice denied, but in a high profile case with a lot of resources, the prosecutors and the police are going to figure it out. So I understand and appreciate the defense's mindset here of saying, let's try to catch them before they dot all their I's and cross all their T's. And the prelim might not be as clean, and they might not have all these pieces of evidence if we, stretch it for months or even a year, quite frankly.
Yeah. All right, I'm going to put you on the spot for a second, not to wax too philosophical about all of this, but I don't know your feelings on the death penalty, whether you're for it, against it, politically, morally, religiously. Put all of that aside. It's on the books. Is this, in your view, a death penalty case? So we've got a young woman who was sexually exploited when she decided she was going to come forward about that. I'm saying if everything that is being alleged turns out to be true. When she says she's going to come out with it, he decides to kill her. But he's got no criminal record and he's a rather young man. So there's kind of the in a nutshell version of what they're going to be looking at and deciding on to pursue the death penalty in this case.
Yeah, I think the only part of that that's really kind of weighs on his side and the opposition to death penalty here, you mentioned the age, and obviously there's a lot of studies, a lot of science, a lot of mitigation experts, which will come into play in terms of how he was developing still. But outside of that, when you just look at, the things that you had laid out, if taken as true, if proved, if the evidence supports it at trial and pre-trial, I mean, this is, in my mind, up there with as gruesome as it gets in terms of facts, in terms of the way something was committed, in terms of the cover-up efforts. I mean, this is up there, right? I wasn't in the courtroom, obviously. I don't think you were either, but I read about it and I'm taking it as true. The photos that were displayed out there and kind of what scene this was. I mean, this is not your everyday homicide. And I've looked at a lot of autopsies, and you have too, and you look at it with a dry eye. This is one of those where you look at it and you need a few days to, kind of get your appetite back. So this one, politics aside or feelings aside, I think he's a candidate, in that district attorney's office right now to say, if not him, how are we going to, prosecute the next guy for a death penalty? I mean, we'll look at the facts here if they're true. So.
Yeah, no, I agree. I think they're having very serious conversations about pursuing it, because it is about the worst of the worst. Not only what he did to her afterwards, but just the callousness. If, again, all of it is true, the callousness of killing a young woman just simply because you had been, exploiting her and grooming her. And then when she decides to out you and that might affect your career, you kill her. It's like, I can't think of something more heartless and deserving of capital punishment. But we will continue to watch this one and leave it up to them to decide all of that and keep you all updated as this case progresses forward. In the meantime, let's move to Memphis, Tennessee, where a mother facing first-degree murder charges allegedly told police, "I did what I had to do." After shooting a 20-year-old man she reportedly found hiding beneath her 13-year-old daughter's bed. Police responded to the scene to find Rodarius Morton fatally wounded in Kendra Scott's yard with a gunshot wound to the back of Morton's head. A juvenile said they saw Scott yelling, "Who's in my house?" before entering the residence and discovering Morton. According to another witness, Morton was invited in through a back door of the home before the eventual confrontation that spilled over on the front porch before Morton's death. Morton's means of entry and the potential threat he posed to the mother and her household will likely be pivotal to Scott's defense as we continue to monitor it moving forward. All right, this one's a tough one because I think it's going to be incredibly fact specific, and I don't know if we have all the facts just yet. But, when you first hear the kind of headline version, mother shoots man hiding under daughter's bed, you think to yourself, why aren't we handing her an award rather than charging her with a crime? But there could be more at play here as to whether or not how he gained entry to that home, if he was invited or not, or what happened. But for right now, just kind of tell us what issues you think they will be looking at. Self-defense, does the home matter? Does it matter where he's in the home? All of that.
Yeah, it all matters. And just to open up, I wrote down essentially what you had started with. I wrote down, street justice or regular justice. And there's a moral aspect to this. And I don't necessarily believe in jury nullification, but there's a lot of individuals that hear the headline and maybe even they see what come out at trial and they say, well, she did the right thing, even if it's not, textbook self-defense. Putting that aside, obviously we do need more facts. I've done a handful of self-defense cases. I've sort of built out a specialty there, and a lot of minute details can matter. I mean, it doesn't look great in the sense of he's shot in the back, right? That's never a great sign for self-defense. Right. He's in the yard. He's not in the house anymore. For all intents and purposes, he's attempting or trying to flee, and there's no imminent danger to the mother or to the daughter at this point in time, just from a very clear self-defense aspect. Now we don't know, right? Was he running out and making threats? Was he potentially reaching into his pocket? And there's a plausible argument that he was armed. I've had trials like that, and there's nothing in the person's pocket, but there's enough reasonable belief that there might be. Self-defense can really turn on those types of details. It can turn almost always on the testimony of the defendant in a self-defense case. So a lot more needs to come out. There was one fact or one allegation, which is not so great, which is apparently the daughter had told law enforcement or told somebody else that the mom had pre-warned her and said, if I find him in this house again, or if he comes over here, some sort of premeditated statement, which is never great. No. For self-defense, you want it to be first time encounter, bang, bang situation. We don't know each other. We never thought about this. We didn't wake up today and say, if I run into this person, I'm going to do X, Y, Z. So for all intents and purposes, very difficult from what we know right now from a classic self-defense case. But again, there are interesting defenses. And I think based on where he is in the yard, what kind of history maybe that she knew about of his. However, at the same time, there was a report that he might have some mental issues or special needs. So again, that's going to weigh against the defense here as well.
Yeah, it's as is most self-defense cases, the facts are so important in helping them assess the reasonableness of the defendant's actions. So we're going to have to really get a much better understanding of what took place here. But you brought up something about how jurors may react to this not entirely following the letter of the law. I think that's a very real concern for prosecutors in this case. Even if the prosecution is able to say, listen, the guy was fleeing, and the reasonableness of her actions and her response in that moment and kind of splitting hairs, I could see some jurors just saying, hey, man, he had it coming. How do they combat that as a prosecution team?
Yeah. I think first, just to point out, this is one of these cases where I kind of tell clients, I'm like, if we get to the gray area, we can win from the optics and from the moral standpoint. If we give the jury something to hang their hat on in terms of reasonable doubt, everything else is in our favor. Everything else is in our favor in terms of the moral defense or the street justice defense or what a civilian really wants here. If we can get there, then as you said, let's get them to that reasonable doubt. Okay, it might not be the perfect self-defense case, but they have enough to go back there and say, we're definitely going to side with her on this situation because we believe in all this other kind of stuff that's clouding the case a little bit, just to point that out. How do prosecutors combat it? I mean, it is a difficult job. I think a lot here, quite frankly, might turn on what the relationship was between the daughter and the individual. The reports are making it seem like this is consensual to a certain extent. Again, there might be some statutory issues there, but obviously, look, if this was erring more towards a sexual assault or rape type of situation, it's going to be a not guilty. It might not even go to trial, quite frankly. No prosecutor wants to touch that. If this is quote unquote consent, even though there are some age issues, prosecutors can still kind of play around with this guy not being the worst individual of all time and kind of dealing with a victim, as they find him, but they don't need to get up there and defend a quote unquote rapist or someone that's sexually assaulting a girl and then he's shot in the back of the head. They can speak for a 20-year-old man that has special needs, that thought he was in a proper type of relationship, he was told it was okay to go over the house. I mean, that's a much easier person for them to stand up with. And look, it is hard. It's hard to deal with a jury selection when you think you might have some rogue individuals or individuals that are just going to, kind of not really care about the law and that the optics might be against you. So they need to be extra careful and vet that out and really get the law and order type of people that are going to, listen to the judge, listen to self-defense. Don't let your emotions get the better of you here. But this could be a close call, this case, just kind of based on all those other factors that we don't always see. It's a really interesting fact pattern.
Yeah, it is. And we will continue to keep an eye on it because I do. These types of things really fascinate me when it really comes down to taking a part of the law that we seem to have our head wrapped around and then just continuing to twist interesting facts into it and see how it all plays out. We will keep it there for now and move on to our final case out of Concord, New Hampshire. The woman at the center of a salacious murder plot is seeking a new trial more than 30 years after her conviction. Pamela Smart was sentenced to life without parole for the 1990 killing of her husband, Gregory Smart. While Smart didn't pull the trigger, she was found guilty of manipulating a 15-year-old student she was sleeping with to carry out the slaying. The minor, William Flynn, admitted to his part in the killing and has since been released on lifetime parole. Smart now wants another bite at the apple, claiming that evidence was misrepresented at trial when jurors were given a transcript to a recording where Smart allegedly confessed to masterminding her husband's death. According to Smart's legal team, the transcripts deceptively directed the jury to hear Ms. Smart making inculpatory statements not actually present in the audio. Smart's attorneys claim they can demonstrate the transcript's effects on jurors through so-called bathtub recordings that one juror recorded in their bathroom detailing their thought process on the case. In one recording, the juror reportedly claimed that Smart couldn't be convicted without the tapes and specifying that jurors couldn't understand what was on the recordings without the supplied transcripts. Judge James Kennedy took Smart's arguments under advisement and is expected to deliver a ruling sometime in the next 2 months. Okay, let's put aside these bathtub recordings for just one moment. Let's say it is in fact true that the transcripts were a pivotal part of all of this. The most clearest indication of her connection to this crime. And they are bad audio. And it is something where you're kind of listening to or watching the transcript as you're listening and might be allowing your ears to hear things that you're pre-programmed to believe are being said because you're reading the transcript, if you follow what I'm saying. How big of a deal could this be? And tell us, how are transcripts supposed to be considered by jurors?
Look, it's a big deal, but there's some issues. I think first and foremost, a lot of states, I know New York and I think many others, when you get a situation like this, you often get an audio recording, and sometimes the defense or the prosecution, depending on who's admitting the audio, will say to the judge, look, judge, we created a transcript. We've showed it to the other side already. That's step number one, right? At the actual trial, did they show it to the other side? Did the other side object? Did the other side make any edits or not? The second phase is the judge says, okay, I'm going to accept this and I'm going to give it to the jury. And phase two is I'm going to tell the jury as I give it to them that they're only to use this as a guide if they need help in hearing something. And it is a fine line, right? Because our eyes are then glued on wanting to read it and thinking that it's accurate. And the limiting instruction is not that powerful, right? If you're given a transcript and you're listening to something, your eyes are probably going to go to what's on paper and just take that as true and accurate. It would be a better process if you listen to the audio and the judge afterwards said, do any jurors need to raise their hand because they couldn't hear any of the segments? If so, we're going to play it again and we're going to give you a transcript this time to follow along with. That would be sort of a perfect world. It doesn't seem to happen that way, but I think we need to dig a little bit deeper about at trial where her lawyer showed the transcript before. Did they make any edits? Did they stipulate? Did they agree? And then it feels like a direct appeal issue afterwards to say if they did object to an appellate court, which I'm sure happened, and say, look, this was a mistake to allow this in. The appellate court obviously denied it here. I'm sure that it was an appeal issue. So I don't know if this is really new evidence. I don't know if it's material. I don't know how powerful it is. I don't know if any other jurors other than this one bathroom juror felt impacted by it. And it feels like a pretty big stretch to say that this is the piece of new evidence that we're going to kind of get her a new trial on, especially if the prior appellate records went into this issue. There could be an ineffectiveness argument, although it's a high standard, but maybe her lawyers at trial just glossed over it. They said, oh, we don't feel like reading the transcript. You're right. It's 30 pages. Just put it in. We trust you. those are big issues, because I've had issues back and forth with defense and prosecution where we're both trying to interpret it the best way possible. And this case goes back to, the 80s or the 90s. So the audio was not that great. So hopefully her lawyers did fine tooth and say, no, there's issues with this. You're having her, admit to XYZ. We can't hear that. We're not allowing that in. So it feels like it needs to be examined a little bit closer as to what happened at the trial level. I don't know if I constitute this as new evidence per se, unless some other jurors, including this one, come in with an affidavit and give a little bit more context to how it affected their deliberation, maybe some kind of further issues there with it.
Yeah, I've had more than one trial which has dealt with transcripts where there's been a dispute about what's being said.
Right.
And it is funny. I mean, it can become hugely important down to a word. And I'm trying to think of how we resolved it in other cases. I had one trial where the judge just had each side submit their own transcript and said, here's what the defense believes it says. Here's what the prosecution believes it says. I think I kind of had a problem with that because as the prosecutor, I was saying, well, they're just suggesting their arguments in this. There has to be some sort of reasonable a reasonable interpretation of what's being said, but that's how the judge decided to handle it. In recent memory, too, for people following, this was became an issue in the Alec Murdaugh case. If you remember that he was giving discussions in a recorded interview inside of a vehicle, and there was one point where he said they did him so bad, and some believed he was saying I did him so bad in a kind of momentary slip. Anyhow, it can come down to one word is what I'm saying. So these transcripts could be important. In the last few minutes that we have left, though, tell us about these bathtub recordings and why they're important, because they're demonstrating that a juror did, in fact, rely on this. Is that something they need to establish for the appellate court?
I don't know if it needs to be established in and of itself or that's dispositive, but it goes to the totality of circumstances, right? We talk about materiality and what affected a juror, and I do a fair amount of appellate work, and I always look at the deliberation process and see if any notes were sent out. And there's some case law in New York and elsewhere which says, look, this supports that the jury was this was a material part of their deliberation and their verdict because they zoned in on this exhibit, or they zoned in on this transcript, or they zoned in on the transcription of it. So the recording of the juror actually talking about what his or her mindset is and how it was an important piece of evidence. I mean, that's a strong part, I think, for them in this. And I think that's why the judge took it under advisement. I think if it didn't have that piece of it and they were just speculating, it's very easy for an appellate judge or judge later on to say, there's no way to say that this had impact, because you see that a lot with appeal work, with work for looking for a new trial. You have to see if it, affected, if it was material. Did it affect their verdict? Did it affect the jury deliberation? And what better support do you have than a recording of at least one juror saying that this is, a big deal to us right now? So, I think it is. I think if they can get other jurors, that would be a big way to bolster the situation here. If this juror says, oh yeah, I spoke with so-and-so, you should speak with them, and affidavits and other pieces came in. I mean, again, I do a good amount of appellate work, and we always kind of target who was on the jury. Let's speak with them. Let's see what was going through their mind. Let's see what things outside the trial came into play here. And, this seems like one of them. So,
yeah. Well, they expect to give a decision, or at least this first phase of the appeal, through the instant judge that's hearing it within the next few weeks. Right. We'll continue to keep an eye on it, but we're going to have to leave it there for now. Jason, thank you so much for coming on this week. Tell us, where can people find more about you? Do you have a website, social media? What can they look up?
Yeah, basically all my information is at Jason Goldman Law, and that's my website as well, jasongoldmanlaw.com. Handle all sorts of criminal defense, federal and state, as well as some civil litigation, usually a criminal crossover in those, but based out of Manhattan, handle cases around the country. And I really appreciate you having me on, Josh.
Absolutely. We loved having our chat. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can check out my YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments, please tweet us your questions with the hashtag TCN Sidebar. And thank you so much for joining us at the True Crime News Sidebar.